Good morning, I'm Gary DeWaal, and this is Pitch of the Week for August 21st to 25th, and today is August 28th, 2017. A former portfolio manager's conviction for insider trading was upheld by a federal appeals court, which in doing so admittedly stepped back from the reasoning of one of its recent decisions. Also, an investment advisor agreed to settle an enforcement action brought by the Securities and Exchange Commission for failing to have and follow policies and procedures reasonably designed to prevent insider trading. Separately, ICE Futures US again settled a disciplinary action with a trader grounded on an alleged violation of the exchange's anti-spoofing rule when, on multiple occasions, the trader purportedly placed only a single large order on one side of the market to induce the execution of a small order on the other side. I am packing my bags to begin a one-week holiday hiking at Yellowstone National Park, so I have time to get some bear spray before I catch my flight to avoid becoming tomorrow's dinner for some hungry predators. Let's get started. Last week, a three-judge panel of the Federal Appeals Court in New York City upheld the September 2014 conviction of Matthew Martoma, a former portfolio manager for SAC Capital Advisors LLC, then a hedge fund, for insider trading. The court held by a 2-to-1 vote that, contrary to guidance issued in a 2014 decision, a corporate insider who has a fiduciary duty not to disclose any material non-public information of his company, a so-called tipper, and a non-insider who receives material non-public information, a so-called tippee, are not required to have a quote-unquote meaningfully close personal relationship to infer the tipper's receipt of a personal benefit for a gift of proprietary information to the tippee. According to a 1983 decision by the U.S. Supreme Court, the receipt of such benefit is a requisite to a finding that a tipper breached his or her fiduciary duty to his or her company. Only if a tippee knew or should have known that the tipper was breaching his or her fiduciary relationship to his or her company can a tippee potentially be convicted for insider trading. Previously, the Supreme Court ruled that absent a breach of fiduciary duty, there is generally no prohibition for market participants from trading on material non-public information. In 2014, the same New York Federal Appeals Court had ruled contrary-wise to its current decision in a decision reversing the insider trading conviction of Todd Newman and Anthony Chiasson, former portfolio managers, for insider trading. There, the court held that, in its prosecution of the defendants, the U.S. government failed to demonstrate that the initial insiders from whom defendants' liability ultimately derived received sufficient personal benefit to establish their securities law liability. In part, this was because there was no meaningfully close relationship between the tipper and tippee. The court said it changed its views following an intervening Supreme Court decision. Deerfield Management Company agreed to pay a fine of $3.946 million to the Securities and Exchange Commission to resolve charges that, from 2012 through 2014, it failed to have and enforce policy and procedures reasonably designed to prevent the misuse of material non-public information. According to the SEC, during this time, the firm, an SEC-registered investment advisor, did not have policy and procedures that addressed the risk that its employees could use material non-public information illicitly obtained from its research firms, particularly those specializing in political intelligence. Previously, criminal charges were filed against 5 persons, including 3 Deerfield partners and analysts, for allegedly dealing in confidential and proprietary information first obtained from a government official, passed along to a consultant, and then passed along to the 3 Deerfield partners who used the political intelligence to fashion trades for Deerfield-managed hedge funds. For the second week in a row, ICE Futures US settled a disciplinary action based on allegations of spoofing, with the alleged wrongful conduct purportedly constituted placing single large orders on one side of a market to influence the execution of single smaller orders on the other side of the market. In the recent matter, Trevor Stanley agreed to pay a fine of $30,000 and to serve a 120-day trading suspension on all ICE Futures U.S. markets to resolve charges that, from April 2016 to July 2016, he engaged in a quote-unquote pattern of trading activity involving the placement of a single large order involving the Russell 2000 Index mini futures contract on one side of the market and a small order on the opposite side. According to ICE Futures US, Mr. Stanley would cancel the large order shortly after a small order was executed. ICE Futures US claimed that Mr. Stanley's trading activity caused quote-unquote order book imbalances, prompting the execution of his smaller orders. 2 weeks ago, Dominic Minervini, a former floor broker registered with the Commodity Futures Trading Commission, agreed to pay a fine of $200,000 to ICE Futures US to resolve similar charges that he may have engaged in impermissible spoofing type activity involving sugar number 11 futures contracts based on similar fact patterns. An interesting development in spoofing law worth noting. And finally, the Canadian Securities Administrators published guidance regarding how securities and derivatives laws in Canada might be impacted by initial coin offerings and the sale of investment funds consisting of digital tokens. Generally, according to the Canadian regulators, Canadian law requires the use of approved disclosure documents prior to a sale of securities unless the sale is conducted pursuant to a private placement in reliance on a prospectus exemption, the registration of businesses and persons involved in the trading or advising of securities, again, unless there is an exemption, and the compliance with marketplace requirements for platforms that trade securities, again, unless there is an exemption. As in the U.S., token sales associated with an initial coin offering may be considered a security in Canada, said the Canadian regulators, if it involves an investment of money in a common enterprise with the expectation of profit arising significantly through the efforts of others. Prospectus exemptions may be available to sophisticated investors known as accredited investors. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week in 2 weeks, ciao.